Hi, folks. This is Kip Malek from Malek and Malek, and I'm going to talk about working wage loss compensation. And this is basically when we get a lot of clients, they go back to work and they're making less money than they made before. And so they ask, what can we do? And this is what you can do. You can file for working wage loss compensation. So there's a few things that you need to do. It's not just like everything with the BWC. It's a process. Um, so if you ever talk to various people, they have acronyms, or they have BWC means better workers comp, and because we care, and then there's some other silly little nicknames for BWC. But like I said, as with everything BWC, there is a process. So the deal with working wage loss compensation is, one, you have to show that you are suffering a wage loss, and the way you do that is by showing your paychecks. So you have your paychecks, and then the other thing you need for working wage loss compensation is you need to have restrictions relating to your work injury. So it has to be a wage loss. You actually show you have a wage loss, and you have restrictions relating to your work injury. And the first step is you fill out this application for wage loss compensation. It's called a C-140. So you just fill this out. They have your work history. They want to know if you've applied for Ohio Department of Jobs and Family Services, among other things. So you fill this out, or you ask your attorney to help you fill it out, and then you take this to your doctor, or your doctor may have this form, and they fill out this second side, which is for the doctors, and they're going to put the restrictions in this form. Okay? And the deal is, if you are granted working wage loss compensation, they have to submit a new this form, or a Medco 14. They have to have updated restrictions. It could be the same restrictions. Irregardless, it has to be done every 3 months. So you can't, the doctor can't do it like fill this out for 6 months in the future. They can only do 3 months at a time. Okay, so that's the C-140. Now, if you're suffering a wage loss, and it's because you're working 20 hours a week, whereas before you worked 40 hours a week, and you have restrictions relating in this form that says, hey, he can only work 20 hours a week, he or she can only work 20 hours a week because of the work injury, then that's the end of what you have to do. Okay? If you have work restrictions with an hourly restriction, and you're working those hours, so if you're only working 20 hours, and you have restrictions of only being able to work 20 hours, and whereas you worked 40 hours before, that's the end of the story for you. If you just have like physical restrictions, for instance, before you could lift 100 pounds and push 100 pounds, and now you can only lift and push 10 pounds, that's a physical restriction. And if that's you, then you have to do something else. So you have to fill out a C-141 wage loss statement for job search. And if you look at this form, there's 4 places for employers. So 1, 2, 3, 4. And if you actually read this thing, it says complete more. You should use more than 1 form for each week. So you basically have to apply to 8 places, at least 8 places a week. If you want to apply 100 places, that's up to you, but it has to be 8 places. So the caveat with this is it has to be a good faith job effort. So it has to be jobs that you could potentially get and can potentially do with your restrictions, or without, I suppose, but with your restrictions. So I guess without restrictions, then you wouldn't need to fill out and get working wage loss, possibly. But irregardless, so not a good faith job search would be applying for the NBA. If you're in Ohio, applying for the Cleveland Cavaliers. I'd assume about 100% of us are not going to be working for the Cavs. Applying to be the CEO of American Electric Power, unless that's something within your cards. But it has to be something that you could do. So, for instance, if you worked in a restaurant, apply for other restaurant jobs, or apply for a job in a warehouse doing picking or something. whatever. It's just something you can do, and so you do that each week. Submit 8 of those, and another very, very, very important thing that you must not do is submit fake applications or fake employers, or even real employers that you haven't contacted. If you do that, you can get in real hot water, and it could be a real problem for you. So if you do that and the BWC finds out, and they're very, very zealous about searching for fraud, then at best you'll have an overpayment of all the wage loss you received. At worst, you could be prosecuted for committing criminal fraud, so that could involve jail time and then fines that you may have to pay in addition to the overpayment. So you have an overpayment plus have committed criminal fraud. So don't make up job searches. Again, a good faith effort, something that you could do. And so that's that. So you'll submit that, and then the BWC will process it, and they'll either start paying you the working wage loss, or you may, as with everything BWC related, you may have to go to a hearing before the Industrial Commission as to why you should be entitled to, or whatever technical issues come up. And working wage loss is paid at, again, 66 2/3 of your average weekly wage. So the wage loss that you're suffering, it's going to be paid at 66 2/3. So it's not 1-for-1. So and that's kind of, I think that's the impetus or the motivation for having you do these job searches, because they don't, if the idea is they want you to get a job where you're making as much money or more than you're making before your injury, so you could get off the BWC benefit train, and then move on with your life. But that's I think that's the motivation, or I would assume that's the motivation behind these job search deals. I do agree it's pretty onerous to have to apply to 8 places each week. I mean, I don't know. It would be hard for me, frankly. So I don't know. It's kind of like doing taxes or something. But so for all those people that are doing this, I commend you, and I have a lot of sympathy, as I do for all injured workers, frankly, who are going through the BWC process. It's not fun. But so that's working wage loss. You could get it for up to 200 weeks. And you could also apply for something called non-working wage loss, and you could get non-working wage loss. And when you apply for non-working wage loss, you're going to do this job search thing as well, and you can get non-working wage loss for 52 weeks. Now, if you get working wage loss and non-working wage loss, and I don't know if I said this before, but you get working wage loss for 200 weeks. So you don't get 200 weeks of working wage loss and 52 weeks of non-working wage loss. Why not? Who knows? But the BWC, or the legislature of Ohio, has said we're not going to pay 252 weeks of this working wage loss, non-working wage loss. So you get 200 weeks of wage loss, and then, or working wage loss, and then you would get 26 weeks of non-working wage loss. So it's pretty simple. The most onerous part of this thing is getting the restrictions from your doctor, and getting that every 3 months, and then submitting this wage loss thing every week. And in addition, you must submit your paycheck every week. So you're going to submit these wage loss statements. You're going to do 8 searches each week, and then you're going to submit your pay stubs, and then you'll get your working wage loss. And then hopefully, by submitting like a boatloads of job searches, you find something that you're paid as much or more than you did before you're injured. That's the hope. So and finally, you don't have to be working at the place where you got injured. So for example, let's say you got injured at Bob Evans, like you're grilling some tasty pancakes and you burnt your hand, or you slipped on some grease in the kitchen and bopped your head on the side of the table. and then you go back to work. But you don't have to go back to work at Bob Evans. Let's say you go back and you go back to another restaurant, like you go to Applebee's or Max and Ermis. You do all this stuff, and then if you're given working wage loss, this expense is not going to be assessed against your new employer. It's going to be assessed against the employer where you got injured. So if you got injured at Bob Evans is essentially going to be could be financially responsible for this. So don't feel bad. You're going to mess up your new employer and they're going to be mad at you. So that's not the case. And you don't have to go in the same kind of field. Like, let's say you got injured at Bob Evans, you could work at Amazon's warehouse and get working wage loss. So as always, hopefully you found this helpful. And if you have any questions or comments or concerns, you can post them below. You could always email me. I will try to answer your questions to the extent that I can, in light of the fact that we don't have an attorney-client relationship, so that puts some limitations on what I can and cannot do. Otherwise, have a nice weekend, and hopefully you avoid getting injured. And if you're currently injured, hopefully you have a speedy and quick recovery and you're back to gainful employment, and you're all healed and better. Okay, thank you very much, and I'll see ya.